5 seconds to go. Start. The licensing regime under the MV Act and the MV rules, when read as a whole, does not provide for a separate endorsement for operating a transport vehicle if a driver already holds a LMV license. We must, however, clarify that the exceptions carved out by the legislature for special vehicles like e-carts and e-rickshaws or vehicles carrying hazardous goods will remain unaffected by the decision of this court. As discussed earlier in this judgment, a definition of LMV under Section 221 of the MV Act explicitly provides what a transport vehicle means. This court must ensure that neither provision, that is the definition under Section 221 or the second part of Section 31, which concerns the necessity for a driving license for a transport vehicle, is reduced to a dead letter of law. Therefore, the emphasis on transport vehicle in the licensing scheme has to be understood only in the context of the medium and heavy vehicles. This harmonious reading also aligns with the objective of the 1994 amendment in section 10(2) to simplify the licensing procedure. The above interpretation also does not defeat the broader twin objectives of the MV Act, that is, road safety and ensuring timely compensation and relief for victims of road accidents. The aspect of road safety is earlier discussed at length. An authoritative pronouncement by this court would prevent insurance companies from taking a technical plea to defeat a legitimate claim for compensation involving an insured vehicle weighing below 7,500 kgs driven by a person holding a driving license of a light motor vehicle class. In an era where autonomous or driverless vehicles are no longer tales of science fiction and app-based passenger platforms are a modern reality, the licensing regime cannot remain static. The amendments that have been carried out by the Indian legislature may not have dealt with all possible concerns. As we were informed by the learned Attorney General that a legislative exercise is underway, we hope that a comprehensive amendment to address the statutory lacunae will be made with necessary corrective measures. Just to flag one concern, the legislature, through the 1994 amendment in section 10(2)(e), in order to introduce transport vehicle as a separate class, could not have intended to merge light motor vehicle, which continued as a distinct class, along with medium and heavy vehicles into a single class. Else it would give rise to a situation in which Shri, our hypothetical character, wanting to participate in the cycling sport, is put through the rigorous training relevant only for a multi-sport like triathlon, which requires a much higher degree of endurance and athleticism. The effort, therefore, should be to ensure that the statute remains practical and workable. Now, harking back to the primary issue and noticing that the core driving skills, as enunciated in the earlier paragraphs, expected to be mastered by all drivers, are universal, regardless of whether the vehicle falls into transport or non-transport category. It is the considered opinion of this court that if the gross vehicle weight is within 7,500 kg, the quintessential common man's driver Shri with LMV license can also drive a transport vehicle. We are also able to reach such a conclusion as none of the parties in this case has produced any empirical data to demonstrate that the LMV driving license holder driving a transport vehicle is a significant cause for road accidents in India. The additional eligibility criteria as specified in MV Act and MV rules as discussed in this judgment will apply only to such vehicle, medium goods vehicle, medium passenger vehicle, heavy goods vehicle and heavy passenger vehicle whose gross weight exceeds 7500 kg. Our present interpretation on how the licensing regime is to operate for drivers under the statutory scheme is unlikely to compromise the road safety concerns. This will also effectively address the livelihood issues for drivers operating transport vehicles who clock maximum hours behind the wheels in legally operating transport vehicles below 7500 kg with their LMV driving license. Perforce, Shri must drive responsibly and should have no occasion to be called either a maniac or an idiot, as mentioned in the first paragraph, while he is behind the wheels. Such harmonious interpretation will substantially address the vexed question of law before this court. Our conclusions following the above discussion are as under. A driver holding a license for light motor vehicle LMV class under section 10 to D for vehicles with a gross vehicle weight under 7500 kg is permitted to operate a transport vehicle without needing additional authorization under section 10 to E of the MV Act specifically for the transport vehicle class. For licensing purposes, LMVs and transport vehicles are not entirely separate classes. An overlap exists between the two. The special eligibility requirements will, however, continue to apply for inter alia e-carts, e-rickshaws, and vehicles carrying hazardous goods. The second part of section 3.1, which emphasizes the necessity of a specific requirement to drive a transport vehicle, does not supersede the definition of LMV provided in section 221 of the MV Act. The additional eligibility criteria specified in the MV Act and MV rules generally for driving transport vehicles would apply only to those intending to operate vehicles with gross vehicle weight exceeding 7500 kg, that is medium goods vehicle, medium passenger vehicle, heavy goods vehicle and heavy passenger vehicle. The decision in Mukund Devgan 2017 is upheld but for reasons as explained by us in this judgment. In the absence of any obtrusive omission, the decision is not per incuriam even if certain provisions of the MV Act and MV rules were not considered in the said judgment. The reference is answered in the above terms. The registry is directed to list the matters before the appropriate bench after obtaining directions from Honorable the Chief Justice of India. Story.